Following my previous video about vehicle ownership and registering yourself as the registered keeper with the DVLA, linked in the description below by the way, many of you have asked questions about how is it then that they can take your vehicle if it's on the road, for example when it's untaxed, or for example when you fail to make payments against the vehicle. Now there's a number of different ways that this can happen, so I'm going to explain some of those in this video, but it's not just limited to vehicles either. So welcome back to my channel. I'm a barrister who helps you understand law, but if I could ask you one small favor first of all, because I've been looking at my statistics recently that shows that 60% of you that watch these videos are not subscribed to my channel. So I'd be really grateful if you hit that subscribe button if, of course, you find this video useful. Now that would really help my channel grow and to reach a wider audience and help more people to understand law just like you. So back to vehicles. There are a number of ways your vehicle can be taken away from you. For example, if it's on the road or other public place and it is untaxed, then the police can seize this vehicle to get it off the road, because it must be taxed to be on a public road. The police will ordinarily take it to a police compound, and then you'll have to go and pay all the charges and prove that it's been retaxed, take proof that you are the registered keeper and that you are the person living at that address which is registered with the DVLA to retrieve the vehicle. If you're not the person that is living at that address where the vehicle is registered to as the keeper, you'll need to bring up to date the DVLA records for that vehicle before you can go and collect the vehicle. Also, all of the statutory holding charges and everything else must be paid, and you must prove that the vehicle's been taxed by the point that you collect it. If on the other hand it's a leased vehicle and you fail to make the repayments, then the repossession is going to be from the finance company or somebody working on behalf of the finance company, because they own the vehicle until you've made all of the payments against it. And so if you fail to make all of the payments on time and there's a substantial debt, the finance company might well come and take the vehicle away. But all of this doesn't just apply to vehicles either. It can apply to various items that you possess, which if you owe a debt could ultimately end up being taken away from you to be sold at public auction to repay the debt that you owe. Allow me to explain this a little further. This is known as a warrant or a writ of control. A warrant of control being for the county court and a writ of control for the high court. And there are various levels of value that it must exceed before it can go to the high court. But nonetheless, if you owe a debt, for example a judgment debt, and you haven't paid it, and they've tried various other methods of getting you to pay it, such as sending someone out to ask you to make the payments and you just outright refuse, the judgment creditor, the person to whom the judgment debtor owes money, can get this elevated to the High Court and get issued a High Court writ of control. This can then be executed by bailiffs to come and remove your goods. There are some things that they can't remove, such as tools up to a nominal value of your trade, basic clothing, basic furniture and these kind of things, but anything else like TVs that they don't see as essential, they can take with them and sell them at public auction in order to repay that debt, because there is an order of the court to remove those things in order to make good on that debt. Other methods of enforcement against you could be an attachment to earnings. This is where they can go to the court to get an order to order your employer to deduct some money from your wages before you are paid. That's an attachment to earnings. They can also get a third-party debt order, so they can get the court to order your bank to freeze enough money to pay the judgment debt. You are given an opportunity to fight against this, but the only way that will really work is for a hardship order, which is where without that money you would literally be homeless or unable to pay for food. But in the event that that fails, the court will order the bank to freeze the money, and then at the second hearing, if your application for a hardship order fails, order the bank finally to pay that money over to the judgment creditor. As a barrister authorised to conduct litigation, this is one method of enforcement I've used many times and it's very successful. On many occasions I've had the court order the bank to pay over money in the debtor's account to my client, the judgment creditor. This is after having a successful court case, winning it, getting a judgment, but the judgment debtor simply refuses to pay it. If things get really serious, there could even be a charging order against your house, meaning you can't sell it or any part of your interest in it without first paying the judgment creditor. And in certain situations with a certain amount owing, the judgment creditor could also go back to court for an order for sale. In that situation, the court will consider who's living in the property, who is likely to suffer if the property is ordered for sale. But ultimately, if there are other arrangements that the judgment debtor can make, the court may very well make an order for sale, so that property must be sold, and out of those proceeds there will be a charge on it, meaning that the judgment creditor will receive enough money to settle that debt. So it's not just about vehicles and it's not just about goods, it's also about your bank accounts and your properties as well. But none of that detracts from the fact that you do own these things, and with the vehicle you are just registering yourself as the registered keeper of the vehicle. That's the person that is responsible for the upkeep, the maintenance, the tax, the insurance, and everything else. And if there's a collision and they want to sue the driver, which could even be someone separate by the way, they will be able to go to the registered keeper of that vehicle to find out who to sue and to find out who the driver was. But ultimately it's the registered keeper that will be responsible for that vehicle. So I hope that helps to address some further questions. And again, I'd be really grateful if you support me on my channel by liking the video, subscribe, check out my exclusive content on BlackBeltBarrister.com. And of course, I'm also on Twitter and Instagram if you'd like to follow me there. In the meantime, thank you for watching.